Thank you for joining us for today's program, Slavery and Freedom on the Delaware-Pennsylvania border. My name is Maureen Iplensky, and today Dana Niemeyer, who's an archivist at the Delaware Public Archives, and I will be highlighting the stories of freedom seekers, specifically those who escaped slavery in Delaware through Chester County. This is the culmination of a project that archivists at Chester County Archives and the Delaware Public Archives have been working on throughout the past year or so. So we are both very excited to share the stories of these freedom seekers. Before we get started, I just want to remind everyone that there is still time to join one of the Chester County History Center's upcoming walking tours, including the Revolutionary Westchester Walking Tour and the Underground Railroad Walking Tour. To register for any or all of those programs, please visit the Chester County History Center's event page. And finally, if you have any questions during the program, please put them in the chat box. So throughout this program, you will hear Dana and I mention quite a few times the term freedom seeker. So before we delve deeper, I will quickly unpack that term. Freedom seekers are the enslaved people who bravely escaped their bondage by fleeing north. They risked physical punishment and retaliation by their enslaver if caught, and they often escaped in secret. If they were able to evade capture, it was common for freedom seekers to adopt a new identity once they settled into a life of freedom. So considering that as enslaved people, they were viewed as property, and as free people, they assumed new identities, it can be quite difficult to track down biographical details related to the lives of these freedom seekers. Among the most descriptive accounts comes from William Still, a Philadelphia-based abolitionist who was responsible for aiding over 600 freedom seekers. His book, The Underground Railroad Records, which was published in 1872, highlights the experiences of these freedom seekers. Still took detailed notes about the condition of slavery, specifically the condition of slavery in Delaware, writing that, quote, "While Delaware was not far from freedom, and while slavery was considered to exist there comparatively in a mild form, nevertheless, there was an unwillingness on the part of slaveholders generally to conform to the spirit of progress going on in the adjacent state of Pennsylvania. It was wonderful how the state slaves saw through the thick darkness prevailing and how wide awake they were to escape." While abolition in nearby Pennsylvania did not result in abolition in Delaware, those enslaved in the borderlands were motivated to escape. Chester County is located at Pennsylvania's southernmost border, so it served as an entry point for many of these freedom seekers. Those who were enslaved in neighboring Delaware and Maryland were often mere miles from free soil. Chester County, as described by the author William Castus, was, quote, "a dangerous stop and a hotbed of abolitionism." The county was home to a large community of Quakers, many of whom were vocal advocates for the abolition of slavery. And by the mid-1800s, Chester County held the state's largest population of free Black residents outside Philadelphia. African Methodist Episcopal, or AME churches, which stood at the center of these free Black communities, offered refuge to those fleeing from slavery. Meanwhile, federal law threatened those who aided freedom seekers with large fines and imprisonment. Many residents did not feel compelled to violate these laws, and there are also those who still supported slavery within Pennsylvania. As we will see, slavery persisted in Chester County until at least the 1830s. These ideological differences created deep tensions within the county and, more broadly speaking, throughout Pennsylvania. So Pennsylvania was a stronghold for the abolitionist movement and achieved many firsts in an effort to abolish slavery. In 1688, Francis Daniel Pastoris and Quakers associated with the Germantown Meeting in Philadelphia drafted the first formal anti-slavery petition in the colonies. In the petition, Pastoris and his fellow Quakers advocated for universal human rights at a time when slavery was largely accepted by Pennsylvania settlers and the Society of Friends. Among the earliest Quaker abolitionists was Benjamin Lay. In 1737, he published All Slave Keepers That Keep the Innocent in Bondage, which was among the first published denouncements against slavery in the colonies. Lay was among the most vocal anti-slavery advocates in the early 1700s. Abolitionists continued to organize throughout the century, and in 1775, the first abolitionist society in the colonies was established in Philadelphia. The society was focused on, or initially focused on, intervening in cases where free Black people were unlawfully forced into slavery. In March 1780, Pennsylvania also became the first state to pass a gradual abolition act. While the act ensured that slavery would eventually be completely abolished within Pennsylvania, it also allowed slavery to persist within the state for at least another 50 years. The act created a strict distinction between enslaved people who were born before its passage and those born before or after the act was passed. So those born before or born into slavery before March of 1780 were legally allowed to be kept as slaves for life, while those born after the act's passage were to be held in slavery until they were 28 years old. In 1788, largely due to the efforts of the Pennsylvania Abolition Society, the state legislature passed an amendment to the 1780 Act. The amendment forbade enslavers from forcing enslaved women out of state so that their children were born into slavery. The act also required enslavers to register those born into slavery with their local county. While these efforts succeeded at limiting the growth of slavery in Pennsylvania, we can see that the results were slow to come. And that was, of course, by design. In 1780, as required by the Gradual Abolition Act, enslavers in Chester County registered those they held in slavery with the county clerk of courts. The register lists those who were then enslaved within the county, along with their age, sex, residence, and enslaved status. So this map shows the population of enslaved people in each township within Chester County. The darker regions represent a higher population, so we can see that slavery was more prevalent in the western region of the county, where enslaved people were most often forced to labor on farms. Based off the 1780 register, there were nearly 500 enslaved people within Chester County at that time. The 1788 Act also required enslavers to report those they enslaved who were born after the act passed, or after the 1780 Act passed. The 1788 register listed another 133 enslaved children within the county. So we can compare that to Delaware. In nearby Newcastle County, Delaware, there were over 2,500 people held in slavery in 1790. Within the entire state, there were nearly 9,000 enslaved people. So while Delaware did not depend on enslaved labor as much as its southern neighbors, you can see quite a contrast between Delaware and Chester County, or even Newcastle County and Chester County. As Dana will likely mention, Delaware did not pass legislation that abolished slavery within its borders. So following the 1780 Act that I mentioned, slavery did steadily decline within Chester County, though records at the archives show that slavery did continue to persist here for at least another 50 years. For instance, we can look at the case between Jacob Glasgow and Samuel Hood. In 1803, Jacob Glasgow, who was formerly enslaved by the Watt family in Oxford Township, sued Samuel Hood. And at this time, Glasgow was a free man. Just 5 years earlier, he paid 60 pounds to his enslavers in exchange for his freedom. And although Jacob was free, Jacob's wife Saul, along with their son, remained enslaved. Jacob, who was owed money by the Hood family, offered to pay Samuel Hood 40 pounds in exchange for his wife's freedom. In response, Hood not only refused to pay the debt he owed to Glasgow, but he also threatened to separate Glasgow from his wife and his son. So Glasgow shortly after filed suit, and the case records we have here at the archive do show that the debt between Hood and Glasgow was eventually settled, but those records do not reveal if Jacob was ever able to free his wife. So this case not only reveals that slavery remained entrenched in the county, but it also illustrates the freedom or the limits of freedom for free Black residents in Pennsylvania. Slavery was also well documented within tax records in Chester County. So this is the 1824 tax for Joseph Strawbridge, who resided in Penn Township. As we can see, he was taxed for one enslaved person. And since enslaved people were often merely viewed as property, we can see that details about their life were obscured in the historical record. The septennial census from 1835 also shows the long-lasting impact of the 1780 Gradual Abolition Act. The census shows that Margaret, who was 60 years old, was enslaved in West Bradford Township, and Diana Baum, who was 100 years old, was enslaved in Brandywine Township. Considering that Diana and Margaret were born well before the 1780 Act, they were held as slaves for life. According to the U.S. Census, there were no enslaved people in Pennsylvania by 1850, so 15 years after this. As fewer Black people within Pennsylvania were held in slavery, the focus shifted to those enslaved outside the state who were fleeing to Pennsylvania. From 1793 to 1850, the United States Congress and the Pennsylvania legislature passed acts that allowed enslavers to pursue and arrest alleged quote-unquote fugitives from labor, or who we would now refer to as freedom seekers. The 1793 Fugitive Slave Act permitted enslavers or their agents to seize or arrest such fugitive from labor and to take him or her before any judge. The judge would then review the case, and in most instances, the judge called for the so-called fugitive to return to the state from which they fled. The 1820 Act to prevent kidnapping, passed by the Pennsylvania legislature, was intended to protect the freedoms of free Black residents within Pennsylvania. But the act also allowed enslavers from outside the state to claim alleged freedom seekers as their slaves. The 1850 Fugitive Slave Act was the strictest of these laws. It required residents and officials of free states to enforce the capture and return of freedom seekers. By 1838, tensions among abolitionists and pro-slavery advocates culminated to the point of violence. On May 17, 1838, members of an anti-abolitionist mob set fire to the newly built Pennsylvania Hall in Philadelphia. Built just days earlier, the hall housed the Pennsylvania Anti-Slavery Society and the offices of the Pennsylvania Freeman, which was an abolitionist newspaper. One witness to the destruction reported that, quote, "The rioters assembled as soon as it was dark and very deliberately commenced operations amid the plaudits of the spectators by demolishing the stores in the basement story. This being done, the doors were beaten in and the building was fired in several places. No attempt of any kind was made to quell the riot." The Fugitive Slave Act of 1850 only worsened these tensions. As I mentioned earlier, the act not only allowed enslavers to pursue and arrest alleged runaways, it also required citizens and officials in free states to aid in the capture of freedom seekers. Empowered by this act, Edward Gorsuch of Maryland traveled to Christiana in Lancaster County to capture 4 freedom seekers who were supposedly enslaved by him. He was accompanied by officers and a federal marshal, though when they arrived at the house of William Parker, where 2 of Gorsuch's enslaved people resided, Parker refused to allow Gorsuch to take the 2 away. Soon, free Black residents in the area and white neighbors joined the resistance. And following an altercation between Gorsuch and Samuel Thompson, who was one of the accused runaways, Gorsuch was shot multiple times. Soon after the event, known as the Christiana Resistance, Parker and those formerly enslaved by Gorsuch fled to Canada, and the federal government reacted by charging 41 people, 36 of whom were free Black residents, with treason. Though when Castor Hanaway, a white farmer who supposedly organized the resistance, was placed on trial, the jury quickly found him not guilty. The charges against the others were consequently dropped. And the Christiana Resistance is recognized as a key event that led to the Civil War. Similar cases were also occurring quite frequently in nearby Chester County. So in December of 1820, Samuel Griffith, Peter Shipley, and 2 accomplices who were all from Maryland traveled to Kennett Township, where John Reed, who was formerly enslaved by Griffith, resided. While Reed believed himself to be free, Griffith claimed that Reed fled from his service. The 1820 Act to prevent kidnapping required enslavers to prove before a judge that they held a lawful claim to an alleged freedom seeker. In this case, Griffith ignored this law and attempted to forcibly kidnap Reed in his own home. In self-defense, Reed killed Griffith and Shipley and fled to a neighbor's home. He was arrested the following day and after trial was found guilty of manslaughter. In November of 1821, Reed was sentenced to serve 9 years at Walnut Street Jail in Philadelphia, where he was, quote, kept to hard labor. Though Reed was able to evade the grasp of his former enslaver, he, as we can see in the case, was once again denied his freedom. In July 1849, Henry Lee Brown, who lived in Downingtown, was also kidnapped. He was kidnapped by Amos McFarland in Solomon States. Brown traveled to Wilmington under the pretense that McFarland's uncle wished to hire him. Though the pair did not stop in Wilmington, and they continued on to Baltimore, where he was placed in a slave prison. Once Brown's employer, William Evans, heard about the kidnapping, he went to Baltimore and brought Brown back to Chester County. When the case went to trial, McFarland and States were quickly found guilty, and both were sent to serve time at the Eastern State Penitentiary. The Pennsylvania Abolition Society also became involved in this case. They attempted to convict Thomas McCreary, who they believed was also behind the kidnapping. McCreary, who was from Cecil County, was among the most notorious slave catchers in the region. And McCreary was never charged in the kidnapping of Henry Brown. Just 2 years later, he was back in Chester County and he kidnapped two free Black sisters from the Nottingham area, Rachel and Elizabeth Parker. Elizabeth, who was kidnapped before Rachel, was forcibly brought to Baltimore as well, and she was immediately sold south. She was later found in New Orleans and returned to Baltimore, where the courts, while the courts there determined whether she was free. Rachel was also brought to Baltimore, and it was there the sisters remained until 1853, when the Baltimore County Court found that the sisters were legally considered free people. Although they were not able, the sisters were not able to return to Chester County unless the Pennsylvania Attorney General agreed to not pursue charges against McCreary and his accomplices. Although the case was brought before the Court of Quarter Sessions in Chester County, Maryland refused to extradite McCreary to Pennsylvania, and he never faced any charges for the kidnapping of the Parker sisters. So as I just mentioned, the 1820 Act to prevent kidnapping required enslavers from outside Pennsylvania to present proof to a judge that they held a lawful claim to an alleged freedom seeker. The act intended to protect free Black residents in Pennsylvania from being kidnapped, though, as we just saw with the series of kidnapping cases, the act was often ignored. When enslavers did present their claim to a judge, the judge was required to create a fair record of the case. Pictured here is the case record filed by James Riddle of Newcastle, Delaware, in October 1829. Riddle claimed to hold Samuel Richardson as his servant, and Richardson had fled from Riddle just the previous month, but was quickly caught in Chester County. He was forced before the court, and as in most cases, the judge found Richardson to be legally bound to Riddle and issued a certificate of removal, which allowed Riddle to force Richardson back to Delaware. So we can see, although freedom seekers were on free soil, they were in Pennsylvania, they were offered little legal protection. Freedom for Black residents in Pennsylvania, whether they were free or actively fleeing from slavery, was often fragile and limited. But was this the case in neighboring Delaware, just over the border of Chester County? I will now pass it on to Dana, who will delve a bit deeper into the history of slavery within Delaware. And I'll stop sharing real quick.
Thank you, Maureen. So as Maureen has stated before, Delaware has had a very complicated relationship with slavery, and then in turn, relationship with free Black residents within the state. Many pieces of legislation were passed over the years regarding both free and enslaved Black residents. And I do want to preface that before 1776, Delaware was considered the three lower counties of Pennsylvania. However, even during this time, the counties were able to pass some of their own policies and regulations. After independence, Delaware further separated itself from Pennsylvania with its policies and legislation, just in general, even without this context. And then as I continue going through the Delaware laws, I do want to preface that I did include the names of these laws as they were listed within the laws of Delaware. And as they were given at the time. Some of the language in these books and these pieces of legislation is now considered to be harmful or offensive, but they are representation of their time, the time at which they were created, or their creators' perspectives. We do believe that retaining these original descriptions preserves historical accuracy and provides valuable social and historical context, as well as will aid you if you want to then look at these yourself and delve a little deeper with the digitized either Laws of Delaware books or pieces of legislation on our website. So getting into that, I did want to start looking at the laws before Delaware's statehood. So I want to begin with the 1731 Act for the Regulation of Servants and Slaves. And this specified that slaves or indentured servants could not be transferred to a person outside of Delaware without the approval of a justice of the peace. It also prevented people from trading with a slave or indentured servant without the written consent of their master. It also did make the statement and claim that free Black residents were, quote, slothful and often prove burdensome to the neighborhood wherein they live, and that they are evil examples to slaves. So that is unfortunate language. And to prevent this, the state did require masters to pay the state 30 pounds for each slave they set free if they were above the age of 35 years old. That harkens back to that language thinking that they were then unable to provide for themselves. So having that 30 pounds have to be paid to the state not only provided the state additional funding for support that they believed they were going to need, but also did prevent another burden to freedom with these manumissions. Because without receiving that payment from the master to the state, the individual would not be considered free until that was done. And in addition, the act required the children of free Black residents to be bound out to service if the parents were deemed unfit to provide for their children. Male children would be bound until the age of 21, and female children would be bound until 18. Additional penalties were also laid out for free Black residents entertaining servants or slaves, taking a slave over 10 miles from their master's property without written permission, and for harboring or employing another person's servant or slave without their written permission of their master. If any of these fines couldn't be paid, the party at fault would be bound into servitude for a set number of years. And this kind of did continue throughout legislation. I'll talk about it again with some of these other acts passed. But it really did limit what you could do as a free Black individual, as well as putting some preventions for manumissions. 1767, the supplement to the previous act actually did raise the amount required to pay the state for a manumitted slave. It doubled it from 30 pounds to 60 pounds. And it also established a punishment for slaves if they assaulted another slave, approving lashes up to 39 lashes and a fine for the owner. So we can still just see here, as time passed, the changes in these laws and kind of making manumissions a little bit more difficult. Though there were harsh restrictions, there were groups committed to helping Black residents of Delaware. We can see here a petition from a group of Delaware Quakers to the General Assembly, looking to grant Black residents such, quote, such relief as justice, humanity, and the common natural rights of mankind, and above all, the precepts and injunctions of the Christian religion. Within this petition, they do acknowledge that these people, referring to the Black residents and slaves, were brought against their will into the state, and they do express the belief that slavery should be abolished within Delaware. I think it's important context thinking back to what Maureen was discussing earlier with the Gradual Emancipation Act, and this petition occurring after that occurred in Pennsylvania. The petition shown here was read to the General Assembly, and an act for authorizing the emancipation of slaves was written. However, it was not passed by the General Assembly. It was written in 1786, but unfortunately it was not passed, leaving slaves in bondage within Delaware. So moving forward, Delaware's legislation continued to change, with the Delaware General Assembly passing an act to prevent the exportation of slaves in 1787. This established a system of permits that must have been granted by the justice of the peace in the county where the slave resided for exportation to occur. It also set the permit cost at 100 pounds and specified a 100-pound penalty if exportation was attempted for a slave who had earned their freedom. This also established that the payment that I discussed earlier for manumissions, that indemnity, was not required if the individual being manumitted was between the ages of 21 and 35 and was deemed healthy. It also created a fine for people bringing slaves into the state when the slave was already deemed free elsewhere. It goes on to list a variety of restrictions on free Black residents, including that they could not vote, be elected or appointed to a position, give evidence against a white person in a trial, or enjoy other rights other than owning their own property and being able to obtain compensation for an injury of themselves or to their property. This, I would say, would be difficult given the fact that they were unable to testify against a white resident if that was the situation at hand. And it also stated that if a free Black person were found guilty of any of those specific crimes, they could be exported to the West Indies or another place for a term not exceeding 14 years. So that is yet another example of just these restrictions placed on even these free individuals within Delaware. In 1788, the General Assembly once again received a petition regarding the Black residents, whether they be free or enslaved. This time it was from the Delaware Society for promoting the abolition of slavery. Within this position, the group calls attention to the act to prevent the exportation of slaves, which is what we just discussed. They explained that it was, quote, done in a manner too easy and light for the gravity of the case. This group brings up an example of a ship that docked at the port of Wilmington, planning a voyage to the coast of Africa for the purpose of bringing more slaves into the country. This group also asked for measures to be adopted to prevent the unnecessary cruelty to slaves within the state. A supplement was passed in 1789 to the act to prevent the exportation of slaves, specifically barring any vessels equipped for the slave trade from docking in Delaware. So while the group may not have gotten petitions for all of the other aspects that they wanted, they were able to get the slave trade kind of barred from docking in the state. Continuing in 1791, the act featured here specified that slaves could not be freed on verbal contracts. It specified procedures for manumissions, including the requirement for a proper number of witnesses and the recording of the manumission. It also specified procedures for trials and punishments for crimes committed by free Black residents within the state. So a lot of these are called the same thing or very similar terms, but there are slight differences then whenever you look at the text of each act. As Maureen has mentioned before, 1793 saw the passing of the Fugitive Slave Act, which was federal legislation that required slaves to be returned to their masters and also placed penalties on individuals who helped escape slaves. In 1793, Delaware saw the passing of an act for the punishment of practicing of kidnapping free Black residents. This enacted the following punishment for individuals convicted of this crime, which included being publicly whipped with 39 lashes on the back, standing in the pillory for 1 hour with both ears nailed, and then after the hour having passed, having the soft part of both ears cut off, otherwise known as flogging and ear cropping. A special bail was also set for the individuals charged with these crimes, and the laws set permit regulations for the transferring of slaves, specifying which judges could and could not grant licenses, whether a person caught exporting a slave without a permit. If that was the case and they were caught, the slave would then be freed. Delaware did have individuals who participated in what is often referred to as the Reverse Underground Railroad, taking free Black residents into slavery, with the most notable participant being Patty Cannon, who operated on the Maryland and Delaware border until her death in jail in 1829. And then in 1797, this act pictured here updated the manumission procedures, once again specifying that they could not be verbal and must be written and processed through the Delaware courts, which was similar to that act passed 6 years prior. 1807 saw an act pertaining to the, quote, better regulation of free individuals, Black individuals, that set additional regulations on what they could and could not do within the state of Delaware. It prohibited any free Black residents from leaving the state of Delaware for more than 10 days. If they were caught staying longer within the state, they would be arrested, brought to a court, and if convicted, forced to pay a fine not exceeding $30. If they could not pay that fine, they would then be sold by the sheriff as a servant for a term not exceeding 7 years. This was unless they had written testimonials and a certificate from 2 justices of the peace from the state where they traveled from, attesting to their moral behavior. If they had these documents, they could be permitted to remain in the state of Delaware. This act also specified other crimes that could permit a free Black resident from being sold as a servant, including larceny. It also barred the intermarrying of free Black residents with white residents, establishing fines on the church where the marriage occurred if they were caught. It also established fines and punishments if a white woman bore a Black child and if a white man was found guilty of committing fornication with a Black woman, though it did specify that Black residents could not testify against white men even within these matters. 1810 saw an act that specified in cases where a slave was set to be manumitted at a certain date, they would remain a slave until that time had passed. It also specified that children of a female slave born within her enslavement would be slaves until the male children reached the age of 25 and the female children the age of 21. There was once again a listed penalty for exporting or selling slaves without a license, and it also required the registration of children of free Black residents within 12 months of their birth. 1811 saw another act, this one enjoining certain duties on the justices of the peace, trustees of the poor, and constables. And this also required the registration of free Blacks residents in Delaware and their children, also specifying that if the children were not being sufficiently provided, that the justices of the peace could bind their children to an apprenticeship. Male children would be apprenticed until they turned 21, and female children would remain apprenticed until they turned 18, with all apprentices receiving $3 at the end of their apprenticeship. 1826 saw an act relating to the fugitives from labor, and it stated that if someone fled into Delaware from another state or territory, they would be arrested and had to go before a judge. So if a freedom seeker from another state was traveling through the state and got caught, this would be the process. The procedures included a certificate for their removal and placed a penalty on any person found to have hindered the investigation. It specified that if a white person were found to have carried someone bound to another over water, specifically, remember, we're on the bay, they would be fined up to $500 and a year of imprisonment. If a free Black resident were found to have assisted in this way, they would be punished by a fine, imprisonment, or public whipping. All Black individuals traveling throughout Delaware without a pass would be caught and tried as if they were a runaway. So if they were a freedom seeker, even if you were free, if you didn't have a pass, you would be considered a runaway as well by the Delaware General Assembly. In 1849, the Delaware General Assembly gave the Justice of the Peace jurisdiction to issue a warrant for free Black residents reported not to be supporting themselves through work. If after a hearing they were found to not have the means of support, they would be ordered to be hired out as a servant until January 1st of the next year, being provided wages, sufficient food, lodging, and clothing. And then if within 30 days of the end of the year, the individual had not found a means of supporting themselves, they would be hired out again for as many years as necessary. So that is just another example of how, like, just that constant fear of being then bound out to another individual once again, despite having your freedom. And then the act pictured here from 1863 established that no free Black resident of Delaware could leave the state for more than 5 days unless they were employed by a white resident as a waterman or wagoner. So this lessens the time, as before we mentioned earlier that it was 10 days. So by 1863, they reduced that to 5 days. And it also stated that no free Black person could enter the state unless it was temporary and in connection with trading. It deemed it unlawful for free Black residents to hold outdoor or camp meetings, attend political meetings, own a gun, pistol, sword, or other warlike instrument. If a white person were found to have loaned or sold a weapon to a Black resident, they would be fined. It also put a fine on captains or conductors bringing in Black residents or Black individuals for the purposes of attending a group meeting. It was unlawful to hire or harbor a free non-resident. Religious meetings for Black residents could not occur after 9 p.m. And no meetings could be held by a group of Black individuals if after sunset, unless 3 white men were present. It also specified that there were no meetings could be held for religious worship outside the county of residence. Black residents could not vote or hold office if they were absent from home after 10 p.m., unless it was due to sickness or a task from their employer. They were to be fined, and then there were specifications for whipping. And then most of these rules resulted not only in just fines if caught, but if the fines could not be paid, then the individuals could be sold back in to servitude. So this is just overarching. All of these rules were in place and really just hold the fear of being then put back into a situation that you're not wanting to be. So how can you really be free with all of these stipulations? Moving forward, though, in 1865, the 13th Amendment, which made slavery and involuntary servitude illegal, was submitted to the states for approval and ratification on February 1st, 1865. However, in response to this, Delaware's legislation adopted a joint resolution in relation to the proposed constitutional amendment prohibiting slavery or involuntary servitude within the United States. And that was on February 8th, 1865. Within this joint resolution, the Delaware General Assembly declared their, quote, unqualified disapproval of said proposed amendment to the Constitution of the United States, and hereby refused to adopt and ratify the same. So Delaware did not ratify the 13th Amendment in 1865. However, despite their disapproval, the 13th Amendment was ratified on December 6, 1865, and proclaimed on December 18, 1865. Within February of 1866, the legislature passed another joint resolution, this time regarding federal relations. Within this, they expressed the desire for the preservation of the rights of states, disagreement with the creation of the Freedmen's Bureau, and unhappiness with the discussions around Black voting, claiming the, quote, superiority of the white race. And this shows Delaware's continued disagreement with the policies enacted by the federal government regarding the treatment of their Black residents. Despite this, after emancipation, emancipation happened throughout the entire country in 1865. However, there is a case in New Castle County in 1868, a pair of cases involving a mother and daughter, Rhoda and Mariah Handy, who sued their former master, Thomas Jefferson Clark of New Castle County, for wages they earned between the ratification of the 13th Amendment in September of 1868. According to the newspapers and the court dockets we have, Clark kept the women as slaves during this time, not telling them that they had been freed by the federal government. When the trial went to court, the women demanded 42 weeks worth of wages. During the trial, Clark argued that there was a Delaware law stated that Black residents could not testify against a white man. However, the court determined that this law was nullified by the passing of the 14th Amendment. Ultimately, these women received their pay, $250 each. And these cases showed how in Delaware, despite emancipation and the passing of additional federal legislation ensuring the rights of Black citizens, there was still a long way to go within the system. Delaware did finally ratify the 13th, 14th, and 15th Amendments in February of 1901, which is shown here on this slide. And with this, I do feel like it is important to understand not only Delaware, but Pennsylvania laws regarding Black residents, whether they be free or enslaved over time, because it helps provide additional context surrounding the lives of these freedom seekers that we're going to discuss within the rest of this project and presentation. Within our project, we did choose to highlight 8 freedom seekers who escaped, as Maureen said, from Newcastle County into Chester County, Pennsylvania. There are 8 individuals listed here, but Maureen and I have both selected one each to discuss with you today. And as we move into this, I want to once again just remind everyone that these narratives are based on the available records we're able to locate in both of these states. It is difficult to track these freedom seekers, but we've done our best within the last year or two to be able to find these for you guys and share their stories. So I'm going to discuss our first person. Her name was Margaret. Margaret was born around 1812 and was enslaved by a merchant named Jesse Moore, who resided on the corner of Orange and Harmony Streets in the town of Newcastle, Delaware, which we can see pictured here on the Beers Atlas map. We can see on the 1820 census that the Moore household contained 2 Black people, a free Black man who was between the ages of 14 and 25, and an enslaved girl under 14 years old, who we believe to be Margaret. And you can see the census at the bottom of the slide. According to an 1829 petition, Moore agreed to free Margaret by Christmas Eve of 1834. She would have been nearly 22 years old at that time, and the practice of setting a date of manumission was not out of the ordinary in Delaware. But until the necessary procedures were completed on the date of the manumission, enslaved individuals like Margaret would remain bound, which we kind of discussed a little bit looking at those pieces of legislation earlier. Margaret, however, did not wait for Moore. Instead, in the summer of 1829, when she was about 17 years old, she fled into Chester County, Pennsylvania. As Maureen mentioned, that fleeing from enslavement by traveling to Pennsylvania was very common. Remember that the Pennsylvania legislature had passed the Gradual Abolition Act in 1780. So that kind of produced a significant population of free Black residents in Chester County, many of whom offered to help those escaping enslavement. On July 11th, 1829, Moore appeared before James McGivens, a justice of the peace, to issue a warrant for the arrest of Margaret. While researching, we did not find any evidence that Margaret was then caught. Despite finding no evidence, we do believe that we located Margaret within additional records. We can see that in 1843, Margaret Jane Lewis married an Absalom Culp at the St. George's Presbyterian Church in Newcastle County, Delaware. On the 1850 census, we were able to locate the couple residing in Wilmington, where Culp worked as a laborer. We believe that Margaret Jane Lewis is the same Margaret who escaped from Jesse Moore, because in 1848, she bound out her son, John Wesley Lewis, to Jesse Moore. And thinking back to the various laws we discussed earlier, it was fairly common for Black Delawareans whom, if they were deemed, quote, financially incompetent, were forced by the state to bound out their children. So it was not uncommon for Black parents to opt to bind their children as apprentices, whether forced to or not. We don't know why Margaret bound her son as an apprentice to Jesse Moore, especially if it is the same Margaret, or why she chose to come back to Delaware. But we can see that a Wesley Lewis was present in the 1850 census within the household of Jesse Moore. The slide shows the apprentice indenture for John Wesley Lewis to Jesse Moore, and then the bottom shows that part of the census record for the Wesley Lewis listed. However, we know that John Wesley Lewis did not complete his apprenticeship with Jesse Moore, because Moore died in 1854, and upon his death, his widow sold John's apprenticeship to another farmer, Benjamin Culp, for $125. And then by 1856, his apprenticeship was once again transferred, this time to a James Cannelly. And we can see on the census record listed below that J.W. Lewis is listed as an apprentice to farming with Cannelly on the 1860 census. Margaret did have another son, Samuel Culp, who was also a farmer. But though by the 1880 census, he had returned to his family home where he was listed as 22 years old. Margaret's story does show the complicated reality of freedom in a state which at its core was very much not free for these individuals. The strict laws restricting free Black residents shaped the lives of individuals like Margaret and her sons, restricting their lives despite escaping from traditional enslavement. And then I'm now going to pass it back to Maureen, who's going to discuss the journey of another freedom seeker.
Okay, thank you, Dana. Mm, Okay, so as Dana mentioned, along with Margaret, we looked at both of our collections across the Delaware Public Archives and the Chester County Archives to see if we could learn anything else about or find any records that detail the experiences for other freedom seekers coming to Chester County. One of those people were also Samuel Brown, and he also escaped from slavery in Newcastle County, Delaware. In 1821, James Brindley, who was Samuel Brown's enslaver, presented this petition to the Delaware General Assembly, and the petition offers some detail about Brown's early life. Brindley wrote that Brown was formerly enslaved by Samuel C. Hall in Cecil County, Maryland. Hall also enslaved Brown's mother, Hannah, and his siblings, Betty, Anne, and an unnamed infant who was just 2 months old. Following the death of Hall, Brindley claimed Jim, Hannah, Betty, Sam, Anne, and the infant as his property. Though, as Dana mentioned earlier with the Delaware laws, Delaware law forbade Brindley from bringing these enslaved people into the state. That is, unless he received permission from a judge or from the General Assembly. So that's why this petition is filed with the Delaware Public Archives. The following month, the General Assembly allowed Brindley to bring Jim, Hannah, and Hannah's children into Delaware, where they would be enslaved under the condition that Brindley executed regular articles of manumission, which meant that he vowed to liberate the males at the age of 30 years, the females at the age of 25 years, and there was an exception for Hannah, Samuel's mother, who would be freed at the age of 32 years. Considering that Sam was just 5 years old at the time of this petition, that would mean he would not be freed until 1846. Samuel was also the youngest son of Hannah, so this meant he would be freed many years after his mother and years after most of his siblings. Brindley resided in Christiana 100 in Newcastle County, Delaware. It is likely here where Samuel Brown was forced to labor. And this 1849 map shows just how close Brindley's property was to the Pennsylvania border. Just to the south is also Wilmington, and Wilmington was the epicenter of the abolition movement within Delaware. On November 22nd, 1831, Brown, who was then just 16 years old, fled from Brindley. By December, Brindley offered a $50 reward for any person who caught and arrested Brown. This advertisement, which was published in the Lancaster Intelliger, offers a brief description of young Samuel Brown. So the article shares that he was, quote, strong and well made and stood at 5 feet 7 or 8 inches. The ad also reveals the physical harm of slavery. It reads that Brown had, quote, a small rupture in his stomach occasioned by rough treatment while an infant. And also listed are the items that Brown took with him during his escape, which included a cotton cord, 2 waistcoats, a cotton shirt, woolen stockings, and a sealskin cap. Sam was caught in Chester County 2 months after his escape. On January 10th, 1832, he was brought before Judge Isaac Darlington, who determined whether, or he oversaw the case to determine whether Brindley did hold a lawful claim to Samuel Brown. Darlington heard the testimony of Lones Taylor, a farmer from West Goshen Township, who was also Brindley's brother-in-law. Taylor testified that he, quote, had known Sam for several years to have been in the possession of and claimed by Brindley as his servant. Darlington also claimed that Brown fully acknowledged that he belonged to the said James J. Brindley. So together with Taylor's testimony and the quote unquote voluntary confession of Samuel Brown, that was enough evidence for Darlington to issue a certificate of removal, which allowed Brindley to force Brown back to Delaware. Brown may be documented in the 1840 census record as a simple tally mark. At this time, there was one free Black man within Brindley's household who was between 10 to 24 years old. So at this time in 1840, Brown would be about 24 years old, and he may have been marked as free since Brindley intended to free him at a later date. So again, based off that manumission record we saw earlier, that Brindley signed in 1821, Brown was set to be freed in 1846. By 1850, Brown was not listed within Brindley's household. His absence suggests that Brindley may have honored the Articles of Manumission. And archivists at both the Chester County Archives and Delaware Public Archives were unable to identify or locate any records that did detail Brown's life into freedom. So as Dana briefly highlighted, and as I mentioned in the introduction, this program was really inspired by a project that archivists at the Delaware Public Archives and the Chester County Archives have been working on for about the past year or so. And Across State Lines is a digital project focused on the stories and experiences of freedom seekers, specifically freedom seekers who fled slavery in Delaware through Chester County. So I'll just highlight a few of the resources available on that site. We searched through collections across both of our archives with the goal of finding as much detail as possible about the lives of these freedom seekers. As Dana shared, even putting our collections together, we had more detail and more insight into the lives of these freedom seekers, but some of these biographies that we built are still not very detailed just because of the conditions that these freedom seekers were living in. And featured in the exhibit are 9 freedom seeker biographies, and you can see that Margaret and Samuel Brown are also included here. You can also learn more about the specific laws passed in both Delaware and Pennsylvania that strictly regulated slavery within their borders. The exhibit includes this interactive timeline that not only delves into the details of these laws, but that also includes specific events that occurred in consequence of these laws. And if you're interested in learning more about the people who were enslaved across both Pennsylvania or both Chester County and Delaware, you may also visit the site's resource page. We listed collections across both archives that document the history of slavery within our regions. Okay, so with that, we will switch it over to questions. And if we do not get to your question by the end of the program, you are free to call or email either archives.
Okay, so this is Stacy from the Chester County Archives, and I've been monitoring the chat box. We've got two questions. One is, can you address any recommended resources to learn more about this topic? So that was a broad question. So if you all have something that is your go-to resource, if you could mention that.
I have a few books on my desk I can recommend. And Dana's probably familiar with this book, but there's this book, A House Divided, which talks about a lot of the laws that Dana mentioned about how slavery and freedom for Black residents was regulated in Delaware. In terms, oh, I thought here it is. In terms of Chester County, there's this other book called Just Over the Line that also breaks down the history of slavery within Chester County.
Okay.
And then I would also recommend, of course, the collections I highlighted in the resources page.
Okay.
So those books are fantastic resources. At the Delaware Public Archives, we also have an African American subject guide, which I posted in the chat, that you can access directly on our website. I specifically did a lot of my research with the Delaware laws and then within our legislative papers collection, both of which you can access under our digital archives page on our website as well, if you wanted to get into that sort of style of things.
Perfect, thank you. We had a question from Dave W., who, Maureen, you addressed this at the end, but if you might want to circle back around and just answer the question. How would slave catchers even find those who had escaped to freedom without databases, without photographs, seekers using new names, how to first find the seeker and then to prove that he or she had been enslaved?
Yeah, that's a great question. So, as you saw with, or as we discussed a little bit with Samuel Brown, it was very common to for enslavers to place a slave advertisement or announcing that their enslaved person ran away. And those included, it can include a great deal of information, like we saw with Brown. They described what he looked like, any like distinctive marks. So with him, he had like a wobbling gait and what he was wearing. And then there was a reward placed most often for anyone who arrested and caught the freedom seeker out of state. And I'll stick to the example with Brown, but we saw that Brinley's brother-in-law so, was a witness to the case. He gave testimony in the case. So you can see how people in the surrounding region, once they are alerted that through the papers that an enslaved person escaped, then they can use that information to catch them and in that instance force them before the court.
Okay, perfect. Have either of you come across any information about a Joseph Tatnall or the use of Brandywine Mills as either part of the Underground Railroad, land or water? Is that familiar to either of you? Specific question.
Mm-hmm.
That is not something that I personally came across in our research. A lot of I think the focus of this project was trying to find what we could about these specific individuals we were able to identify within both of our collections. So that one was not something, but it's sure something sounds interesting. And I would be very intrigued if you're able to find anything on that.
Okay.
Yeah, I'm not familiar either, but in that book by William Still that I mentioned, the Underground Railroad Records, may be useful to see if they're just to see who his collaborators may have been. I'd be curious if the person you're researching pops up there.
Okay, that's a good. Now, another question about Mennonites being involved with early abolition. Any research that you've come across in that? Either of you?
I have not.
Okay.
Yeah, I can't speak too much about the Mennonite involvement in the abolition movement. Um, I know in Pennsylvania, the abolitionist movement, which I mentioned early on in that timeline, did center on Quakers, but that they certainly weren't the only people kind of pushing that movement along. So, but I can't speak to Mennonites specifically.
So we're just about 5 minutes after. I know we have a limited time. So if we did not get to your question in the chat, please feel free to reach out to either of the repositories by email or give us a call. But we're very thankful for all of you for attending and hanging in with us for the entirety of the program. We will be sending out a link to the recording as well as the chat transcript as that was requested. And thank you, Maureen. Thank you, Dana, so much for your time and your expertise in sharing it in such a accessible way. It was very, very, very well done. So thank you.
Thank you. And thank you everyone for attending today.
Yes, thank you all for attending.